Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss a very good case law decided by Honorable High Court of Madhya Pradesh regarding sending of the accused for DNA profiling according to Section 53A of the crpc. Honorable Single Judge Vishal Misra, Justice Vishal Misra, in the case of Durgesh versus State of Madhya Pradesh in Criminal Miscellaneous Petition 52891 by 2022 on 9th December 2022, directed the Director General of Police, Madhya Pradesh, to give circulars and also to give training to the police authorities to see that, to ensure that the mandatory provisions of CRPC, particularly Section 53A, are followed regarding DNA profiling in rape cases. This is the most important issue. How the thing has happened. So don't be under the wrong impression that police officers do not know that they have to send the rape accused and rape victims for DNA profiling. But here, a typical case. Now, coming to the facts of the case, please remember, Durgesh, he was accused of committing or kidnapping, committing rape on a minor girl aged about 6 years in the PS limits of Adagon PS of Shironi district in Madhya Pradesh. Right? A case was registered against him in crime number 363 by 2021 under sections 376 clause 2, 363, 506 IPC. So 363 kidnapping, 376 rape, 506 is criminal intimidation of the Indian Penal Code, as well as sections 7 and 8 of the POCSO Act, that is Prevention of Children from Sexual Offences Act 2012. Right? A case was registered against him and he was arrested on 23/11/2021. The girl's dead body was traced elsewhere. Anyway, he was charged with the so-called rape and murder. Incidentally, what happened is, please remember, the mother and the victim, she did not die. She was alive. That's the 3 is not added. So she was taken, she was raped, and subsequently this man was arrested. Yes. During the trial, the mother and the victim, both of them turned hostile. Maybe due to so many reasons, we do not know, but they did. And this fellow who was arrested on 23/11/2021, he has been in jail. So he filed a petition for bail under section 439 CRPC. Actually, this is a matter relating to bail. But the government pleader on behalf of, actually we can say public prosecutor, on behalf of Madhya Pradesh state, he vehemently contended that no doubt they turned hostile, but the DNA profiling was not done. DNA profiling was not done. And the judge asked, what were you doing so far? Then the public prosecutor, he relied on the case of Chotko versus State of UP, stating that the victim was subjected to medical examination, as well as the accused was also subjected to medical examination. But the thing is, since the forensic analysis or since the medical examination disclosed any spermatozoa on the salwar of the so-called victim, they did not go for DNA profiling, but simply to say, according to section 53A, whenever a person is arrested accused of rape, he has to be sent before the medical examination, and the medical officer may use such force as necessary and he has to conduct the examination and he has to give a certificate. There he has to conduct the DNA profiling also. And of course, what the medical officer can do, unless you write it, the IO, investigating officer, has to write that DNA profiling has to be done. So this was not done. It has become an advantage for the accused. Ultimately, since he has been hanging over in the jail for a long time, and since the mother and the victim, they have turned hostile, of course, the court was considerate to give him bail, to release him on bail after furnishing a surety for 50,000 or things like that. But the important point you have to learn is that the provisions of section 53A CRPC, they have to be mandatorily followed, right? So for this, the Honorable Justice has given a case law, Raja Burman alias Rahul versus State of Madhya Pradesh. So they have to be sent for DNA profiling. This is most important. It's a technical evidence. No doubt sometimes the semen may not be present, but if you do the DNA profiling, they may match. So this is important thing. So ultimately, Honorable Justice directed the DGP of Madhya Pradesh to sensitize or to give circulars to all the police officers to follow the provisions of section 53A mandatorily. With this, I am concluding. Thank you.